Doesn't sound right. It's fine. Okay, sorry. All right. And members, I detect a quorum, so we're going to start. Civil Justice Full Committee is now in session. Clerk, please call the roll.
Representatives Bricken, Clemens, Curcio, Eldridge, Farmer, Garrett, Gillespie, Griffey, Harris, Littleton, Ogles, Parkinson, Ramsey, Smith, Stewart, Vice Chairman Jernigan,
Here.
Chairman Carter. Mr. Vice Chairman, you have a quorum.
Thank you so much. Members, any personal orders? We have one. This is the first time I think we've had one since I've been here, but let's do it.
Thank you, Mr. Chairman. I'm glad to be the first, I guess, for
really.
personal orders for the Civil Justice Committee. So I just want to take a quick moment and want to welcome a special guest from Gallatin, Sumner County Commissioner Deanne DeWitt. So thank you for being here. If you all would make her feel welcome.
Well, he represents Gallatin well. Okay. So we do have an agenda. We have a calendar here, so let's get started. Item number 1, House Bill 506 has been taken off notice. Which brings us to item number 2, House Bill 899 by Chairman Doggett. Motion. I have a motion and a second. Chairman, you're recognized.
Thank you, Mr. Chairman and members of the committee. 899 has been something we've been working on for a couple of years. We worked on it last year and passed it out of the full judicial before COVID, before COVID took over. And we came back this year and we're trying to move it again. And lo and behold, there's always, when you have ample time to do some things and more eyes get on something, you see issues that others may have with that language. And so we've run into that problem. And so if it's the will of the committee, I would respectfully ask that we could take that off notice.
Yes, sir. Off notice. Without objection, we're going to take House Bill 899 is rolled to our special calendar, which we'll take up today immediately, follow the conclusion of our final calendar. All right.
Will I be required to be present for that as well?
I don't think so. No, you are not.
Okay, thank you.
Stay right there, though. Item number 3, House Bill 902 by Chairman Doggett. Got a motion and a second. Chairman, you're recognized.
Thank you, Mr. Chairman and members. Excuse me.
Chairman, we have 2 amendments.
Yes, sir. Yes, sir.
Which one would you like to move?
I believe the amendment we're looking at is code 7435.
7435. I've got a first and a second. Does that make the bill?
It does.
Let's go ahead and put that on the bill. And then,
yes, sir.
Okay. We're going to move 7435 to put on the bill. All those in favor say aye. Aye. Those opposed, ayes have it. Chairman Doggett, your bill is amended.
Thank you. What this does, we are identifying what a registry is for the purpose of stating that we cannot have one for firearms or firearms accessories in the state of Tennessee. It also lists in there exemptions. Now, again, like previous legislation I talked about, when you have a lot of eyes that come on and able to see what you're doing, we've had to go in and make some minute changes. This amendment that we did here does make a minute change, and it make sure that our colleges and universities, our public institutions of higher education in this state, are not incidentally caught up in this, because they do have to keep tabs on faculty or even students that carry on their campuses. And so we wanted, as a safety precaution, to make sure that they were not going to be affected by this legislation. We exempted them as well in that. Also, we also had in the previous weeks, we had added in the Post Commission, because unfortunately they have to keep records of some of these smaller rural departments that perhaps they are not able to provide their firearms to those officers, and the officers have to provide them for themselves. The Tennessee Post Commission keeps a record of that so that they know those individuals, officers in those departments, what they carry. And so with that, I know that there may be, there's potential for another thing that we may have missed in this, and it came to us with very short notice. But some also police departments have off-duty weapons that officers carry that may be of their own, and their departments take those. They qualify with those weapons. They do everything they're supposed to do, and those departments keep a record of that. And we wanted to make sure that we do not catch them up in that as well. But that is one thing that's been brought to our attention that this amendment does not address.
Okay. Is that your explanation? Or,
That's my explanation, yes, sir.
okay. Members, you've heard the explanation. Are there any questions? Sorry. Oh, Chairman Farmer.
Yes, and Chairman Doggett, thank you for bringing this legislation. I spoke with Ms. Duncan she represents the Sheriff's Association, and we were talking about your bill. Would you be opposed to an oral amendment and what it would do, members and Mr. Sponsor, in section D, C, it's bold section C, and it says, a record of persons assigned firearms, it's on the second page, a record of persons assigned firearms that are purchased or owned by a state or local law enforcement agency. What I would like to do is I would like to strike the word or and add or authorized for carry in the course of employment. So this would then read, a record of persons assigned firearms that are purchased or authorized for carry in the course of employment by a state or local law enforcement agency. What I'm doing is adding the words authorized for carry in the course of employment. Now, I think that helps tighten things up and cleans things up and enhances your bill. It doesn't change in any material way the purpose of your bill. So this would be what I consider a technical change, a cleanup. So I'd move passage of that. Members?
I've got a motion and a second of discussion. So this would not be a substantial change.
I'm sorry, Mr. Chair, what did you say?
This would not be a substantial change.
It is not. I consider this, and I think if members look at it, it just tightens it up and makes this a cleaner bill. It is not a substantive change.
Sponsor, would you consider that a friendly amendment?
Yes, Mr. Chairman. In my closing remarks a moment ago, I alluded to this as that was something that we caught, that we thought we had it covered, but there was just a little bit of gray area with that language. So I'm very thankful that a member was willing to do that to tighten it up. So I am in favor of that if the committee allows it.
All right, so where we're at now, we got a first and a second. It is a proper motion. Is there any discussion? I'm going to allow the verbal amendment. Is there any discussion on the amendment? Got a question on the amendment? Without objection, we're voting on a verbal amendment. There's no to go on the bill. Those in favor say aye. Aye. Those opposed, ayes have it. Without objection, what we're going to do is we're going to take your verbal amendment, roll it into 7435, which is the current amendment, so that's what you'll see moving out. So we're on the bill as amended. Representative Parkes.
Thank you, Mr. Chairman. And just a quick, brief explanation as amended now.
Thank you, Representative. Are you referring to what we just added in verbally or with the amendment?
So what you see your vision for the bill now as amended?
It's in a much better posture. We thought that we had this portion covered. We were wanting to make sure that off-duty law enforcement officers that are authorized to carry, some of those departments, they have to carry their own personal backup duty guns and so those departments keep those records of that. We didn't want to trip them up and cause them to fall and be on the opposite side of what this legislation does. So this exempts them from the definition of what a registry is and the maintaining registry at this time.
Okay, thank you. Thank you, Mr. Chair.
Thank you.
Members, I failed to gavel to putting those two amendments together, so those two amendments will now be rolled in together. And any further questions? Got a question on the bill without objection. We're going to vote on House Bill 902 as amended. Those in favor say aye. Aye. Those opposed? Ayes have it. You're off to calendar and rules? Yeah, calendar and rules.
Thank you very much.
Item number 4, House Bill 357 by Chairman Curcio. I have a motion and a second.
Thank you, Mr. Chairman and committee.
You have two amendments. Which one would you like to move?
Yes, sir. Amendment coded 6930 came out of the sub, but I'm actually wanting to move amendment coded 7274.
Okay.
So I'd like to move amendment coded 7274 today.
Got a
Second.
motion and a second on 7274. That makes the bill.
Yes, sir. It does make the bill. I'll be happy to explain it.
All
if
right,
you'd like.
we're going to put that on the bill. Those in favor of putting 7274 on the bill say aye.
Aye.
Those opposed, ayes have it. Chairman Curcio, your bill as amended.
Thank you, Mr. Chairman and committee. Members, we have created the 32nd Judicial District, and what this bill would do, it says any employee of the 21st Judicial District who transfers to the same position in the 32nd Judicial District as of September 1st, 2022, must retain the same level of salary and benefits subject to the appropriations by the General Assembly and the Annual Appropriations Act. So you've got some folks who have worked out of Williamson County in that 21st Judicial District for a number of years. They're at a much higher pay scale. If they're able to transfer into the newly created 32nd, which is Hickman, Lewis, and Perry, now part of the 21st, we don't want them to go from a pay scale that reflects their 20 years of service now as a brand new greenhorn, basically. So this would keep them whole if they make that transfer.
Members, you heard the explanation. Are there any questions? Representative Clemens.
Yeah, thank you, Mr. Chairman.
I recognize.
What employee transferred, what type of employee transferred from one district to another?
Thank you, Mr. Chairman. So to be clear, this hasn't happened yet. The 32nd Judicial District does not go into effect until September 1st, 2022. But you could imagine there's, say, an assistant district attorney or a victim witness coordinator, for example, who's worked in the 21st for 15 or 20 years. If they stay right where they are in the same office where they've always been, serving the same victims, then we just want to make sure that they transfer over with the same salary and benefits.
Representative.
Thank you, Mr. Chairman. So I just want to make sure we're not endorsing one district pulling someone out of another district or resources out of one district and putting it in another. We're just protecting somebody who's staying in the same location and just happens to be changing district numbers.
Thank you, Mr. Chairman. Yes, sir, that's exactly right. This is just this one kind of unique circumstance where right now you've got Williamson, Hickman, Lewis, and Perry are all part of the 21st Judicial District. When the 32nd takes effect, Hickman, Lewis, and Perry will pull away from Williamson. Williamson will be a standalone district. So you've got folks who've been working in Centerville, for example, in Hickman County, where I represent, been doing a job for 15 or 20 years. They can stay right where they are at the same job. If the new DA or the new public defender will have them, and can stay at the same salary and same benefit level.
Thank you, Mr. Chairman. And my follow-up to what we discussed in the subcommittee is, it's my understanding the governor's going to appoint all these judges, and then they'll be for this year, and then those same judges will be up for election, popular election in 2022.
Thank Thank you, Mr. Chairman. No, sir, to my good friend from Davidson County, we adopted Amendment Coded 7274, and all Amendment Coded 7274 does is it says an employee of the 21st Judicial District who transfers to the same position in the 32nd Judicial District as of September 1st, 2022, must retain the same level of salary and benefits subject to appropriation by the General Assembly in the Annual Appropriations Act. That is all this bill does now. So I believe the language that you're referring to was in the original amendment, which we did not adopt in this full committee.
Thank you.
All right. Any further questions? Seeing none, we're going to vote on House Bill 357 as amended. All those in favor say aye.
Aye.
Those opposed, ayes have it. Off to finance, sir.
Thank you, Chairman and Committee.
All right. Last, item number 5, House Bill 1130 by Chairman Farmer. Motion. Got a motion and a second. Chairman, I've got an amendment. Which one would you like to move out of the two?
Thank you, Mr. Chairman. I would like to move with Amendment 7378.
Got a first and second on 7378. Makes the bill, sir?
It does, but
Okay.
and what it does, it cleans up a couple issues kind of left on the table last week in Civil Justice Subcommittee. One of those being where this court will be held or where this court will sit when cases are to be heard, and that says that they will sit in Knoxville, Nashville, and Jackson. They'll use the Supreme Court buildings there. There's an issue whether or not Davidson County would be able to accommodate the clerk and master and the judges and the clerks that would go along with these judges in Davidson County. So we've looked to clean that up, and also a jurisdictional issue. Well, the question was, what exactly are these courts going to hear? You know, is this intended to hear issues of tort or just issues of state statute with regards to redistricting or legislative intent? And this is what this does. So if the committee would just give me a moment, I just want to just go over this bill, kind of what it does and what this amendment does, because there's some members on this committee that do not sit on the Civil Justice Subcommittee. So this bill would amend.
Chairman, let me put the amendment on the bill, then we'll discuss it.
Sounds great.
Yeah, okay.
Just saying.
Representative Parks, any question on the amendment?
Thank you, Mr. Chair. On the amendment, is there a reason that Jackson Madison was chosen and Shelby wasn't?
Yeah, Mr. Chair.
Yeah.
And that's where the Supreme Court, they sit. That's where our current Supreme Court sit to hear cases.
Okay. Thank you, sir.
So, yes.
All right, we're going to put the amendment on the bill on 7378. All those in favor say aye.
Aye.
Those opposed, ayes have it. So Chairman Farmer, as amended, let's explain it from you, please.
Yeah, thank you, sir. The amended bill creates and establishes a statewide chancery court to hear cases questioning the constitutionality of state actions. This court will be composed of 3 chancellors, each divided and residing among the 3 grand divisions of the state. Each of the chancellors elected must be won by the person from the appropriate grand division, which receives the highest number of votes. These chancellors will be appointed and elected in the same manner current chancellors are elected. However, each judicial district for these judges will be the state of Tennessee. So each chancellor will be elected in a statewide election. This new court will sit in the Supreme Court buildings in Knoxville, Nashville, and Jackson, unless a location is otherwise designated by the Supreme Court. A majority of the chancellors prevails, and the rules promulgated by the Supreme Court shall govern the practice and procedure of this court. The governor will appoint 3 persons to serve as the chancellors until September 1st, 2022. At the August 2022 general election, and every 8 years thereafter, the voters of the state will elect 3 chancellors. The initial term of the chancellors will begin on October 1st, 2021. The jurisdiction. The statewide chancery court has exclusive original jurisdiction over any civil cause of action that meets each of the following criteria: challenging the constitutionality of 1, a state statute, 2, an executive order, or 3, an administrative rule or regulation, and includes a claim for declaratory judgment or injunctive relief, and is brought against a state or department, agency, or official acting in their official capacity, or the Attorney General intervenes on behalf of the state and requests the issue of constitutionality be certified to this chancery court. The court from which an issue is certified will maintain jurisdiction over the remainder of the case and will enter in a stay in proceedings until the statewide chancery court has ruled on the issue certified. The court may not impose a substitute redistricting plan until giving the General Assembly a period of time not less than 15 days to remedy any defects the court identified. If the General Assembly does not enact a new plan within the time period set by the court, the Chancery Court may impose an interim districting plan for use only in the next election cycle, as long as the plan remedies any defects in the General Assembly's original redistricting plan. So in a nutshell, this is what this bill does. It creates a statewide Chancery Court. It's a trial court, in essence. And this court will hear cases with regards to what I spoke about jurisdictionally, the state statute, redistricting, so forth. And a majority of the members of this panel, so majority would be 2 out of 3, the majority would prevail on the rulings. So members, I'll be happy to take any questions that you may have.
I'm not sure that was in a nutshell, but that was,
Mr. Chair, I was trying to answer some questions from last week, and typically, you know me, usually I don't talk that much.
fine.
This is
I
worth
got
it
it.
here. This is a big step, so.
I got Representative Clemens and then Gillespie.
Yeah, thank you. I try not to retread on what we discussed last week in the subcommittee.
Thank you.
Um,
I'm serious about that. I didn't. Thank you.
We had a good discussion. I appreciate it. And it appears you tried to clear some of that up. So where is the clerk being created by this going to sit, as opposed to the judges themselves?
Chairman.
Thank you. The clerk would be held in the Supreme Court here in Nashville.
And so you touched on the ruling is going to be 2 to 3. What I'm concerned about, and actually have a question about now, is, as you know, at the trial court level, you have a series of pretrial motions. You have motions from judgment, motion to dismiss, under the various rules. Are all motions going to be 2 to a majority rule? How is there going to be a panel opinion issued on each motion separately?
Chairman.
Thank you, Mr. Chair, and thank you for that question. I think that with regards to motions, so we say, did you say motion for?
So any pretrial or motions before trial.
Okay. And it's looking at just the jurisdiction here, challenging the constitutionality of the state statute for one, an executive order or an administrative rule or regulation. I'm trying to think of what pretrial motions there would be to hear.
I mean, any pretrial motion. I mean, you're seeking to dismiss the case or any reason if they hadn't stated a claim under various rules. I mean, I'm just curious how the motions are, or we can even discuss. I'll ask about during trial. If you got evidentiary motions during trial or something like that, and somebody objects to something in front of a bench in a trial, are those 3 judges going to confer in private and then rule on it during trial, or how's that going to work?
Right, and thank you. Now I understand your question, and I appreciate the question. As the legislation is written right now, it would be a majority ruling of those judges as well on motions and any pretrial proceedings.
Okay, I just, the logistical nature of this and how that's going to work in a pretrial setting and in a trial setting of a trial court where you have multiple judges, it's just so foreign to anything that we have now as opposed to the appellate or other level. I can't seem to see how this is going to work. And I'm curious, and I suspect they're going to travel from area to area across the state. So, there's only a handful of these types of issues that arise every year, and only a certain amount of even trials or complaints on these specific types of cases. So I'm wondering what these 3 judges are going to do the rest of the year. I suspect they're going to be paid the same as other state court judges. So I'm just curious as to how we envision what other role may they play, or is there any other role contemplated?
Chairman.
And thank you, Mr. Chair, and thank you for those questions, Representative Clemens. As I understand this legislation, as I read it, if there's an issue that arises from, say, if it arises out of West Tennessee, right? So the court will sit in West Tennessee. They'll go there. They'll sit. They'll hear the cases. make the decisions, whether it be pretrial issues, post-trial issues, or pretrial issues, or issues of trial, and then they'll make those rulings there. So, yeah, of course, this is new. This is something that I don't think this is something that the state's never done before. So we're trying to iron out the issues that come before us, and you've had some very good questions, and I appreciate those questions.
Very well. It's the last question. We can
Yeah,
move on.
thank you, Mr. Chairman. I just wanted to say thank you. I appreciate you trying to answer those questions. I think what we have here before us is a bill that, while well-intentioned, I think it's got some real problems, and I think it will create some logistical issues, and I'm not sure that it's even funded in the governor's recent budget, but thank you, Mr. Chairman. Thank you,
Yep.
sponsor.
I do have a quick question, Chairman. Will the legislative body confirm them as well as we do appeals judges?
And thank you, Mr. Chair. As the statute currently reads, that would not happen.
Okay. Representative Gillespie. Oh, he passes. Representative Griffey, then Stewart.
Thank you, Mr. Chairman. Thanks, sponsor, for bringing this legislation. And to my good friend from Davidson County, what I've typically have been familiar with, exposed to, sometimes we've got 3 judge panels. One judge will be the presiding judge and will make all those non-dispositive rulings, and it's up to his or her prerogative on those during trial, pre-trial, so forth. But when it comes up to dispositive issues, there has to be all 3 judges in the majority concurrence in the opinion. So I think that issue can be addressed. And to the second issue, well, these are very good questions from my friend from Davidson County as well. I'm at least somewhat familiar that there's always a number of cases in Tennessee where a judge or judges from a certain jurisdiction would prefer not to sit on it and be involved with the case due to either notoriety of the case or relationships with some of the parties, and to avoid any appearance of impropriety. It's good to call in a judge from outside of the district, and to the extent that this 3-judge panel is not overloaded and has the ability to fill in and sit in those cases, because once you're a chancellor or a circuit court judge in Tennessee, you have full authority to hear all types of cases. You got concurrent jurisdiction on everything. So I would think that this might actually help our court system and some of the judges who are overloaded in those cases that are difficult and burdensome to deal with, that need the attention of one judge. This might actually help address those problems. So I appreciate the legislation. And I did have one question. Do we have separate legislations that's dealing with the redistricting, or is this is the one that's going to deal with the redistricting challenges? Thank you, Mr. Chairman.
Chairman.
And thank you, Representative Griffey, for those comments. As I understand it, the other 2 bills by Chairman Curcio and Representative Garrett have been general subbed in the Senate. So I believe this is the lone wolf that's still roaming around. This is still alive. So,
Yeah, right now. Chairman Stewart.
Thank you, Mr. Chairman. Chairman, my question is, I guess I have 2 questions. Do you know if there's another state in the country that has a 3-judge panel like this that hears trial-level actions?
Mr. Chair? No.
Thank you, Chairman. And the reason I raise that concern is I share Representative Clemens' concerns just about the practicalities of this. I'm just not sure how it actually work in process, and so I was wondering if there was a precedent we could look to. Another concern which I had raised with the bill on the floor is a constitutional one. Has anybody, the Attorney General or anyone else, issued an opinion about whether or not this framework complies with our constitutional provisions about judges?
Mr.
Chairman.
I don't know.
Chairman.
Thank you. I mean, my concern, I'll just raise it now, is that I look at the Constitution, there's a provision that gives us the right to create jurisdiction. so I'm not raising a jurisdictional issue. My concern is that the way the Constitution seems to set up the judicial branch, it seems to anticipate that chancellors and circuit judges, trial-level judges, are elected by the people of their area. And that's the only provision I see for trial judges. I'm concerned that there's just not a provision in the Tennessee Constitution that authorizes the sort of three-judge panel that you're talking about. Whether or not it's a reasonable idea or not, do you have concerns that the Constitution just doesn't allow us to create a three-judge panel, but instead seems to anticipate and require that there be a single judge elected for his region or area that makes the sort of decisions that you're handing over to this panel?
Mr. Chairman.
Chairman?
Yeah, and thank you, Representative Stewart. I appreciate your questions. And I don't have constitutional concerns because these judges are elected within the region that they sit, and our Constitution doesn't speak to that issue specifically. So, like I said, we are in uncharted waters and trying to do something different. So, thank you for your questions.
Okay. Chairman?
Well, and thank you for your response. I guess we'll just go down the road and see, see what others think about our requirements. Thank you.
Okay. I've got Representative Parkinson and Garrett.
Thank you, Mr. Chair, and to the sponsor. We normally align on most pieces of legislation. This one, I'm a little bit. It gives me just a little bit of concern. So, and correct me if I'm wrong. And you mentioned that once after the appointment in September, the 3 judges would run. And I thought I heard you say they would run statewide. Is that correct or incorrect?
Chairman?
Mr. Chair. Yes, that is correct. However, there would be votes tallied, and each eastern, middle, and western districts their votes would be tallied separately, and each person, the winner, and the respective districts would take the top vote getter of the three grand divisions would then take the seat.
Okay, just so I'm clear on it. So they would run statewide from Shelby to Bristol. Am I incorrect in that? Show me how that works.
Mr. Chair.
Chairman?
And I think from a practical standpoint, this is how it would be. It would be considered a statewide election. But say if I were going to run, or if a person was going to run in East Tennessee, you wouldn't be spending money in Middle and West. You'd focus your resources on that Eastern Grand Division, because that's where the votes would be tallied from. So, from a practical purpose, I know we call it a statewide election, but it really be just it seems like a Grand Division election, but the votes would be tallied statewide. Does that make sense?
Not really, but so someone that's running in West Tennessee in that Grand Division a vote wouldn't be counted for them in Knoxville. Is that what you're saying?
Chairman?
Yes, that's what I'm saying.
Okay. And the Grand Divisions, they've been lined off divisionally and shows which counties will be included specifically in the Grand Divisions?
Chairman?
I'm sorry, could you repeat the question? I apologize.
So have the political lines been drawn, have the lines rather, not necessarily political lines, have the lines been drawn as to each county that's included in each Grand Division? That's already been done?
Yes, that has.
Okay. And with this legislation, what are we trying to fix?
I apologize once again. Sorry.
No problem. Just 2 attorneys over there sitting next to each other.
It's hard
and conferring.
to concentrate on anything.
And giving me the we're both going to answer these questions, right? That look. But so the what is it that we're trying to fix with the legislation?
Well, and that's a great question there. And I spoke to this last week. I think what we're trying to do is spread throughout the state to allow folks from east, west, and the middle district of this state to be heard on these constitutional issues, and not just have one area of the state having an individual elected from that specific area, whether it's here in Davidson County as it currently is, or East Tennessee, West Tennessee, north or south there. I think we're trying to spread out the values and the opinions to those 3 grand divisions.
Okay. And Mr. Chair, do you mind if I continue for a couple more?
2 more.
Thank you, sir. So under the model that,
And thank you, Representative Parkinson. Now, one thing, and I've been looking down, because you'd asked a question a while ago. You asked me about the statewide election, right, and how these votes would be tallied. And I'm confident that I misspoke with that answer. So you specifically asked, can a vote in Knoxville count for a Western division, maybe someone is running from Memphis, right? And I believe the answer to that is yes.
oh,
So it is a true statewide, statewide election. So I apologize, I wasn't trying to mislead anyone.
yeah, so, and Mr. Chair, thank you for, the indulgence you're giving me. So that part in itself is a real issue, because now it waters down the vote from, Shelby County, West Tennessee, across the entire state. So it literally stacks the choice of which judge would be representative of that area. And we'll never, ever, honestly, we'll never be able to elect a judge from our area based on this formula. The other thing is was there a problem, what's the problem with the formula that we're operating under now? Because if these judges are elected judges that make these decisions right now, if I'm correct, is there or has there been something that went wrong to get us here to draft this legislation?
Chairman.
And thank you, Representative Parkinson, for those questions. And like I said before, my opinion and my interpretation of this legislation is to try to provide a fair footprint for these judges to hear cases.
And thank you. Last point, Mr. Chair. And I understand that, but under this formula that's being proposed, it doesn't create a fair opportunity for those of us in Shelby County, because the individual that we may choose or want to choose from our area, the votes will be watered down across the state, and so that's inherently an unfair. So, yeah. And so, thank you, Mr. Chair.
Thank you.
Thank you, Mr. Sponsor.
Garrett? You're up.
Thank you, Mr. Chairman. Chairman Farmer, thank you for bringing this legislation. I wanted to make a few comments on sort of some that have already been asked about the practicality of motion practice, et cetera, with this type of court. And, each judge in their particular jurisdiction can, and kind of to piggyback on what Representative Griffey was talking about, make what is their motion practice in their court. For instance, in Davidson County, if you decide to file a dispositive motion, that's a big word, and what that dispositive motion means is that you're trying to get rid of a case, a particular lawsuit, before it actually goes to trial, before it actually is heard on the merits by the trial court judge. That's what a dispositive motion means, either a motion to dismiss or a summary judgment motion, that you believe there's something factually wrong with the complaint that can't survive that particular motion, so you've asked the judge to rule on the pleadings of what the case looks like prior to go to trial. In Davidson County, you can file that dispositive motion, and you've actually, under the Tennessee Rules of Civil Procedure, have 30 days to respond to that. Well, the judges in Davidson County decided, well, you actually have 37 days to file a response. They actually require you to do that. In some cases, in some courts, when you file a motion, like in Sumner County where I also appear, you can file a motion to be heard by the judge, and the judge does not require there to be a response filed. In Davidson County, they actually require a response to be filed if you want your motion to be heard in front of them on the Monday before the Friday that motion is actually filed. They also require that you file a reply to the response by Wednesday. This is particularly in Davidson County. So in this regard, I just want to make sure that you agree with this, Chairman Farmer, that in this three-judge panel, they can make their own rules as they hear whether or not it's a motion that may not be a dispositive motion. They can create their rules of how they handle those particular things, where we won't have someone arguing a motion before them and they've got to say, oh, wait a minute, we've got to have the majority rule. They can actually make the rules if it's the presiding judge or another judge in a different grand division that hears that particular motion, they can create those rules because it's their court to do that with, just like every court does across our 95 counties. There's obviously different ways, the motion practice, et cetera, before each judge's court. They have that ability to do that. And before, and I welcome your comments on that, Chairman Farmer, but a couple of things that I want to make while I believe this three-judge panel is important. A couple of things that have happened in my practice is I file a dispositive motion, which is summary judgment. I was representing a bank. And I'm not going to name the judge, but it actually, I waited over 18 months before I got a ruling on that. The judge ruled I actually did not achieve summary judgment that I was hoping for on behalf of my client. Within 2 or 3 months later, someone filed for bankruptcy, and of course the case went away, but they had that long. So it's important for these issues that you're bringing that these are dealt with swiftly and dealt with folks that know the law, that know the rules, that can then turn around that decision in a quick way. I've got another case that I've filed a motion to dismiss. A motion to dismiss has been filed against me. We've responded. We've had the hearing. And that hearing is in November, and there's still no ruling on that particular case now. So it does take a little bit of time, and I believe this court can be efficient. Finally, I had a case in my home county in Sumner County where every single judge recused themselves, right? Every single, it's the first time it ever happened to me that I actually had to have a judge heard from a different county. And it was the county in Wilson County. It was that judge over there, Judge Wooten. Great guy. He's retired now. And we actually had a conversation with this judge, and I said, well, do we need to appear in what court? Because he appears in several different counties. He is a Crew Circuit Court judge because his jurisdiction is within several different counties. And he said, Mr. Garrett, we're going to hear this case in your home county. Your folks elected a judge in their home county, and they need to be at home in their own courthouse and hear this. And that was several years ago, but that has impacted me on how important it is to have these cases heard by judges that they elect, either in their home county or in this statewide chancery court that we're hopefully creating under your bill now. So they had an opportunity to have their particular grievances heard by a judge that they elected. So I appreciate this legislation, and I wholeheartedly support it. So thank you, Chairman Farmer, for bringing this legislation. I appreciate it.
Chairman Curcio, then Littleton.
Thank you, Mr. Chairman, and thank you, Representative Farmer, for bringing the bill. I know you mentioned earlier that the three of us, well, we were kind of a wolf pack before. We had 3 bills. Would you consider yourself a one-man wolf pack?
Mr.
Chairman.
I consider myself a one-man wolf pack now.
Yeah.
I do.
Chairman, do you have his back?
Yes, I do have his back. Thank you, Mr. Chairman. But a serious question, or just a comment, because I know we've kind of gone around the barn on this one a little bit. But the statewide Chancery Court, I think, correct me if I'm wrong, but Chancery Court can also be known as the Court of Equity. Is that correct?
That's correct.
Okay. There were some comments before about votes being watered down, and so I just want to make sure we know what this process is. The way I read this amendment is that if I'm from East Tennessee and I'm running for one of these seats, or if I'm from Shelby County and I'm running for one of these seats, I will appear on the ballot statewide, if that's correct. And if I say anything that's wrong, please jump in there. But then when the vote is tallied, it will be tallied in each grand division. And those grand divisions are actually defined in code. So the counties are listed out, who's in west, who's in middle, and who's in east. So yes, while if you're from Shelby County and you are running statewide, obviously you're going to have a leg up on anybody else who's in the race who's from middle or east. So that's why when they go to take the tally, they're going to look at it based on those 3 grand divisions. So while if you're from Shelby County, you may be the lowest vote getter in East Tennessee, you could win in West Tennessee because you were the most popular candidate in your grand division. So to me, this really does create kind of the statewide equity where you are running for a statewide elected office, but the vote is being tallied per each grand division, so to make sure that those judges are home folks, so to speak, as Representative Garrett spoke to a moment ago. So I just want to make sure that, is that your understanding of this legislation?
It is, and I appreciate your comments, Mr. Chairman. It is, and I know this bill is, we've been working hard to get this right. And it's been fluid in nature, and I know I'm not always perfect. I misspeak sometimes, but that is my understanding. Thank you.
Chair Lady Lilt is going to beat you to that, but I'll double question on the bill. I have a question called on the bill. Is there objection? Seeing none, we're going to vote on House Bill 1130 to go to Finance. All those in favor say aye. Aye. Those opposed? The ayes have it. You're off to Finance, sir. What's that? No. Okay, well, that ends the calendar. We're now going to take up a special calendar, which has one item, which is House Bill 899. And without objection, we'll be sending 899 to the clerk's desk. All those in favor for doing that, without objection, say aye. Aye. Ayes have it, it's to the clerk's desk. And that will take us to do some personal orders, and I would like to say a few things. I want to thank our committee attorney here, Michelle Fogarty. She's done an excellent job. Our research analyst, Clint Caldwell, and Ben Foytis. My committee assistant, Melinda Price, has been very gracious with me and not literally holding my hand, but she's been holding my hand through this process, and I want to thank her for that. The committee intern, Caitlin Price. Committee clerks, Jordan, is it Nickel, Tara Robbins, and Michaela Puckett. And obviously our Sergeant at Arms, who changes each time, but we want to represent or thank them for their service. And if there's any more personal order from Representative Stewart.
Thank you, Mr. Chairman. Thank you for running a fair process in this committee. This committee ran very fairly for everybody. Everybody got to talk. And I'd also like to thank Chairman Carter, also, who has always done a great job running his committee and also has always had a fair process. You know, my belief is always, regardless of what we believe ideologically, if there's a fair process, then the people are served. So thank you for doing that.
Thank you. Parkinson.
Thank you, Mr. Chair. I just wanted to echo the sentiments of my colleague from Davidson County. I think you've done a wonderful job in managing the committee, and I just want to give you your accolades, man. Great job. Appreciate it.
Thank you, Chairman Ramsey.
And I just want to keep this ball rolling. In a difficult. Oh, I thought it was on. The chairman comes across the hall and says, "Did I do the fair thing?" And I say, "Yes, as long as it was for the Republicans." I'm just kidding. But he's measured himself very, very succinctly and made sure that has been very fair. So I appreciate that. Congratulations, sir.
Thank you. I wish the circumstances were different, but I'll entertain a motion to adjourn. Oh, I'm sorry, Chairman Farmer.
Yeah, I wanted to brag just for a minute on the committee, Vice Chair Jernigan, Chairman Carter. This is one of my favorite committees in the House. One of my two favorite, right? Criminal and Civil. So enjoy being here. Love working with you all.
Yep.
Thank you for all the hard work. Members, thank you for all your hard work, and staff. So.
Okay. All right. So we're going to motion to adjourn, and Civil Justice Committee is closed subject to the call of the chair.